So what is our topic here today? It is estate planning and 3 crucial tax issues, what you need to know. That's what we're here to talk about. And you might not think these issues matter to you, but I promise you they do. And the two certainties in life, death and taxes, oy vey, as we like to say. And you don't know what you don't know about estate gift and capital gains taxes. And a lack of understanding here can cost your family hundreds of thousands of dollars. Again, even if you're just consider yourself middle class, these issues hit basically every American family. As long if you own any assets, if you own a house, if you have stock, these are issues you need to understand. That's what we're here to talk about. And what we don't want you to be like this guy, and I'll show you this image in just a second. We don't want you to have your head in the sand because too many people just don't learn about these issues, and they kind of wait to see what will happen, or they don't want to spend any time or money learning about it, or they don't want to work with advisors, and you get stuck. So our mission here is to educate and empower you about these tax issues. And what are we covering here today? Well, I'll go through the topics. 3 critical tax planning issues and what you need to know. So really dividing this into 3 areas of discussion. One is capital gains taxes, and most importantly, how you can avoid them. So there's a few tricks we're gonna share and some strategies that you can use for your family. Property taxes and Prop 19. If you follow us, we talk about this a lot. The reason is that for everybody who understands this, there's probably another 100 Californians who don't, and it's going to affect so many families. We've already helped hundreds of families in this area, but we know there are thousands more that don't even know it's a problem. So we're going to go through that issue. You might want to share this if you have neighbors or friends who don't know about this issue. We're, of course, going to talk about estate and gift taxes and the coming cliff, what you need to know there. And of course, some action items. And we always have to point out action items that you can take, by the way, or we give a lot of tips that are actionable throughout this to save yourself and your family lots of money in taxes. And of course, this is for educational purposes only. It's not meant as legal advice. It's for education, to empower and inform you, to really give you legal advice. We have to work with you. So you have to contact us and set a meeting, or if you already work with us, you know how it works. We'd sit down with you and understand your situation. So don't try this at home. Make sure you get expert guidance whenever you're really pursuing any of these strategies. We always like to point out, for virtually every tax problem, there's a solution. We can't always eliminate taxes, but we can almost always reduce them. And I do want to point out, we're not income tax experts. That's accountants. This is about, again, capital gains taxes, estate taxes, property taxes. That's where we can add a lot of value. And that's where we want you to understand this. And just briefly, for those of you who don't know us, many of you maybe do, but for those of you who don't know us, we are very proud of our heritage. We are Gilfix and LaPaul Associates. I am Mark Gilfix. This is Michael Gilfix. We're not the only attorneys in our firm. We have 6 amazing estate planning attorneys. We have litigators on our team as well. But we've been in the Bay Area for over 40 years. That picture is me with my grandfather on the top right. We have saved we've served thousands of California families from San Diego all the way up to Wairika. We've been featured in the national media. We write books, we publish articles, we appear in the media. We want to educate everybody, even if we can't serve everybody, but we can serve you. If you're in California, we can help you. And our goal is to provide extraordinary peace of mind and return on investment. And Mike, by the way, is one of, if not the founder of the field of elder law. In 1973, he started America's first free legal aid program for the elderly in America, SALA, Senior Adults Legal Assistance. So he is considered in legal circles to be really the guy who created this field of law. So we're very proud of our heritage, and it's my honor to be working with my dad, Mike, as my mentor and a guide and the leader of our firm. So we're so happy to have everybody here today.
It's a privilege and a pleasure. And by the way, yes, that really is Mark being held in that picture. That's a young Mark Gilfix sitting there. So it goes on and on with the family here.
That's right. We are a family, and we serve families, and we're very
take care of families.
We love meeting so many people in our community. So our first topic, though, today is going to be capital gains taxes. Mistakes can cost your family hundreds of thousands of dollars. Here is what you need to know about capital gains taxes. So Mike, why don't you lead us to a very kind of high level question? What are capital gains taxes, and how do they work?
So capital gains taxes are painful. number one. Number two, really to emphasize, they are a tax of choice. You only have a capital gains tax if you sell an asset. Very important point. So how does this work and what does it mean? Okay, let's take a simple example. A share of stock. You buy a share of stock for $10. That's the cost basis. If you sell it for more, let's say you're lucky, you sell it for $100. You have a $90 profit or capital gain, and you have to pay capital gains tax on that. Now, that assumes that you've held it a year. If you sell it in less than a year, it's regular income tax. So that's not advantageous. So significant tax on the gain. If you bought your home for $100,000 many years ago, as a lot of older folks around here did so, now you sell it for $2 million, you have a $1.9 million capital gain. Even though there's some forgiveness, we'll go through that, enormous capital gains tax exposure. So we have to be wary of this when we're doing our long-term planning, when we're thinking about retirement. You just have to be aware of the issues, and we'll go through many of the important options and planning considerations that you need to know about.
Absolutely.
So what this means is, unless you plan, you could lose 30% of the value of an asset that you sell. I mean, it can be devastating, and it sneaks up on a lot of people, not realizing how punishing it is, having misconceptions about how much you can protect from capital gains tax exposure. So very painful. So Mark will lead us now through the concepts, the things that we think about as we analyze capital gains tax exposure and what you need to know about so that you can avoid them, even if you have to sell an asset.
Absolutely. That's the name of the game, because they are a fact of life. But we're here to give you advice on how to avoid them, some of the strategies that you can use. And we are going to talk about 4 key concepts today. There are many other concepts out there, but these are 4 that we think everybody should be aware of, because these are taxes that everybody faces. So the 4 concepts we're going to discuss: the stepped up basis after death. Mike's going to lead us through that, what that means and why it's so important. And unfortunately, it might not help you, but it'll help your family. He'll lead you through that. We're going to talk about, if you sell your house, what techniques can we use to avoid capital gains taxes for the sale of your house or around that? If you have rental property, 1031 exchange, what is it? How does it work? How can it benefit you and your family? And then we're going to talk about charitable remainder trust. So these are all really important topics to understand. And we're going to walk you through them right here. And again, if you have questions, leave them in the Q&A function. If you're watching this on YouTube, leave a comment, leave a question there. We'll try to respond to everything there as well.
Yeah.
So Mike, why don't you lead us through the concept of the stepped up basis?
Okay, so as mentioned mere moments ago, the cost basis is the price that you paid for an asset. If you sell it while you're living, you have this capital gains tax exposure, which can be devastating. I mean, you think about hundreds of thousands of dollars going out the window. Who wants that? Okay, so first key point about this basis idea is that the basis enjoys what's called a step up at your passing. There is a price to pay for the step up in basis. So if an asset is in your estate as your separate property or as community property for husband and wife, every asset in your community property trust, for example, gets this stepped up basis. So I gave that example of the share of stock that went up to $100 in value. At the time of the first death, doesn't matter what was paid, the new basis reflects the market value on the date of death, $100. If that stock is then sold for $100, subtract the new basis of $100, zero gain, zero tax. At the second death, if the trust is properly structured, there's going to be another, if there's a husband and wife situation, there'll be a second stepped up basis. So again, wiping out capital gains tax exposure. Critically important. If an asset is not in your estate at the time of your passing, doesn't get a stepped up basis. So this raises the point that we have to carefully coordinate estate tax planning with our capital gains tax planning, so to speak. Last comment I'll make before we go back to Mark for some tips has to do with the structure of your trust. We'll talk in a few minutes about this, but whether you have this thing called an AB trust for a couple or not, it bears on this question. So everybody's different, every situation is different. We'll go through that in a couple of minutes. Structure of your trust matters in this context of capital gains tax avoidance.
Yeah, and I'm just going to call it, because when I entered this field of law many years ago, this was a concept that I didn't understand. And I think many people don't get this. It's a huge benefit to your family. Capital gains taxes are wiped out. They disappear when one one spouse passes away for their entire community property estate. It's a huge concept. So I know it's a little repetitive, but it's a huge benefit to the family. Now, the only downside is someone has to die for it, and that kind of sucks. But hey, for the rest of your family, one of the upsides, and we know it's going to happen eventually, right? We have to at least address
gonna happen.
it's going to happen. So now let's go through some specific tips. I'm going to give you 3 tips in just a moment on how you can save in capital gains taxes. There are some key rules you need to understand. Let's go back to some slides. But again, the stepped up basis, a crucial concept. Let's go through 3 tips. So the first tip, so let's talk about your primary residence. When you sell, and this only applies to your primary residence, but as Mike said, if you sell something for more than you paid, that's a gain. And if there's no exemptions, you can lose up to a third of that gain to the IRS in the form of capital gains taxes. Here's what you need to know about the sale of your residence. And I think there's a lot of confusion about this. If you're single and you've lived in your home at least 2 of the last 5 years, and you only have one residence, the first $250,000 in gain is tax-free. So if you bought a house for $500,000, you sell it 2 years later, you lived in it for those 2 years for $750,000, you don't have to pay any capital gains taxes on that. And here's another key concept. If there are 2 people, a married couple on title for that house, and they both lived there for 2 of the last 5 years, you can double that protection to $500,000. You could sell that, you buy a house for $500,000, you could sell it for $1 million, and you wouldn't have to pay a penny of capital gains taxes, again, as long as it's the residence. So where is the strategy in this? Well, you kind of have some choice as to which property is your primary residence. If you have more than one, maybe you move into one for a while and make it your primary residence. If you're single and you're thinking about selling your house in a couple of years, there are a lot of reasons to think about pros and cons of marriage. But one reason to get married from a tax standpoint is you get married, you get to protect $500,000. Mike, do you have a thought?
Yeah. So listen, so if you're single and you have a home and you're thinking of selling it, contact us for the Gilfix dating service. We may be able to help you out. Find a spouse, double that protection. Our services are bountiful.
That's right. That's right. Get married, find the love of your life, and save $250,000. Well, it'd be about $80,000 you actually save in capital gains taxes. So, but there are strategies around this. It's not just as simple as, I get 250 or 500,000. If you have rented a property out, we'll talk about what you can do for rentals, but maybe it makes sense to move back in before you sell it, or there's different things you can do. So $250,000 if you're single, $500,000 if you're a married couple, and if you've lived in a house for more than 2 years. So let me share the next tip. So let's talk about if you have a rental property. We're going to talk about property tax issues a little bit later, but let's say that you have a fourplex and you're really sick of managing it. You don't want to deal with tenants anymore. You want to sell it, and you want something that's more passive or a different type of investment. Well, if you just sell a rental property, you don't get that $250,000 exemption. There is no exemption. So if you sell it for more than you paid, you have to pay capital gains taxes. But if you were willing to take a couple steps, you might avoid all of those. If you do a 1031 exchange, this is in the IRS tax code for a like-kind exchange. If you sell an income property and follow the right steps, you have to start this process before you sell. Then if you buy another like-kind investment, another rental property or rental property investment, you don't have to pay any capital gains taxes. You can roll over your cost basis from one real estate investment to another. So if you have, let's say you have a fourplex that's worth $2 million. I know it's a big price, and you don't want to manage it anymore. You want to sell it. Well, you just sell it, and you bought it for $100,000 decades ago. Hundreds of thousands in capital gains taxes. If you do a 1031 exchange, you could take all 2 million of that and put it into another real estate investment that qualifies it. It doesn't have to be a building, by the way. There are special Delaware statutory trusts. There are passive investments that are actually structured to work for a 1031 exchange. And you can talk to us if you want to learn a little more about that. But if you put it into another real estate investment that qualifies, you pay 0 capital gains taxes. And so there's a way, for example, to take money from an actively managed pain in the butt property to a passively managed where you don't have to lift a finger anymore. And yeah, you might pay some fees, but then you might just get income from that. And rather than taking this huge capital gains tax hit, that full $2 million can go to work in this new investment for you, kicking off income. Now, here's where strategy can come in. If you keep doing this until you pass it, so when you do a 1031 exchange, your cost basis does roll over into the new investment. So if you paid 100,000, now it's worth 2 million, you buy a $2 million other investment with the proceeds, that new investment, if you ever sell it, would have a huge capital gains tax hit. But if you keep doing 1031 exchanges, we have many clients who've done these. If you keep it in your estate until one spouse passes away, all that capital gains tax wipes away. Remember that stepped up basis. So kick the can down the road, or as Mike pointed out in one of our talks earlier, kick the can down the road. You can avoid capital gains taxes. So 1031 exchanges are huge. And again, there are other strategies we can use. Let's say you've had a house in the Bay Area or coastal Los Angeles or San Diego. You've had it for 30 years and it's up more than 500,000. Remember, you can protect the first 250 or 500,000 in capital gains for your primary residence. But let's say you've owned it for decades and it's up 2 million from what you paid for it. You don't want to pay capital gains taxes. Well, maybe you move out for a little while and convert it to a rental and do a 1031 exchange. So there are a lot of techniques we can use here. But I would just say before you sell a rental property or your primary residence, let's talk. Let's see how it had the implications for your estate plan. We can give you some guidance on how you might do this. And we're not realtors, by the way. So we have no horse in the race. We just want to give you great advice about it. So another technique, the 1031 exchange. So now let's go to technique number 3 or strategy number 3. And that is charitable remainder trust. So this would be for stock. If you have appreciated stock. So we talked about how you can avoid capital gains taxes for real estate. Mike, why don't you talk about charitable remainder trusts, when they apply, when you might think about doing this, and the many benefits of these wonderful planning tools?
Sure. So the first thing to say is that many individuals are interested in the charitable remainder trust because they have a charity, a cause they're interested in. We are extremely supportive of the nonprofit world. I started out running one for 10 years. We both serve on boards of directors of nonprofits. So, conceptually and sort of, almost philosophically, we support the concept. Now, it's practical as can be for in this tax context. Here's the idea with the charitable remainder trust. Let's say you have a rental property or stock that's grown tremendously in value. It's not giving you a lot of liquidity or income. You need more income. You want more income. If you sell that stock to reinvest, to generate a higher rate of return, well, remember that capital gains tax exposure, it just undercuts the whole idea. So what you do is you take the stock, you put it into this trust. Then after it's in the trust, the stock is sold. Because the remaining assets are going to go to a tax-exempt organization, there is no capital gains tax exposure. So if you have a $1 million worth of stock, for example, if you sell it regularly, you're going to lose $300,000 to capital gains tax. So in this context, you sell it, you have $1 million to invest, and maybe you set a 6 or 7% annual rate of return. You get income for life at a rate that you set. There's alternative approaches we can take, but to keep it simple, it guarantees income for you for life. And many individuals, by the way, will take that income that they didn't have before, buy a life insurance policy, structure it so that it's not in your trust, and you basically replace the wealth that you might have wanted to go to your kids with a life insurance policy. So again, many tools and techniques. Charitable remainder trust are an underutilized strategy that I think is a perfect fit for so many of us.
Absolutely. And as Mike kind of alluded to, there's a lot of mixing and matching of these strategies that we can use. So we've helped many, many clients to do this. And frankly, this is how many of our clients who started out as kind of middle class have really risen up by smartly leveraging these rules to avoid capital gains taxes. It's extraordinary what we can achieve. Now, I want to spend just a minute on your living trust structure, because we absolutely can help you with this. You need to talk to us if you're not sure about this. But let me just share again another slide about if you're a couple and you have a living trust. There are basically 2 core structures, and we call it AB or not to AB or not to AB. That is the question. And the wrong structure can cost your family, literally can be hundreds of thousands of dollars in unnecessary capital gains taxes. So you might not even know. So if you don't have a living trust, you need to put one into place. We can help, of course. Contact us, gilfix.com. But if you have a trust, if you did it with us, if we met with you recently, we've probably gone over this. But if it's been a few years, it's time to take a fresh look. And if you didn't work with us, we, of course, can take a very efficient look at your trust and tell you very quickly what you have. Now, here's why this matters. Many years ago, estate tax laws, we're going to talk about those in other talks and later here. Estate tax laws were much more strict. And we used to have to use what we call an A-B structure to provide maximum protection for your estate. Without going into too many details, we no longer need that unless you have a very large estate. Now, there are other reasons why you might have an A-B trust, but an A-B trust in simple plain English just means when one spouse passes away, the trust splits into an A trust above ground, the surviving spouse is half, and the B trust below ground, the deceased spouse is half. There are a lot of reasons why this is still done and why it was done many years ago, but here's the problem. If you did it a long time ago, you might have done it for estate tax purpose. That might not apply anymore. And if you did the AB trust, Mike talked about that stepped up basis, right? When someone passes away, everything in their estate gets that stepped up basis. Capital gains taxes vanish. If you have an AB trust, when the second spouse passes away, half of the estate in this B trust will not get a second step up in basis. So if one spouse outlives the other by many years, that can result in hundreds of thousands of dollars in unnecessary capital gains tax exposure. And even if let's say your spouse passed away a few years ago and you have an AB trust and you're like, oh, wow, I didn't realize this was a problem. We can actually fix it after someone passes away too. So the bottom line is we need to take a fresh look at your trust structure. If you have an AB trust, it may no longer make sense to have that. So we want to make sure that we take a fresh look, because that alone could save your family hundreds of thousands of dollars.
Yeah, and let me emphasize a point that Mark just made. Okay, so if you are a surviving spouse, or if you're a child of a surviving spouse, and there is money in this B trust, the share of the estate that kind of flowed from the first decedent, from the first one who passed away, we can fix it. There's a procedure that would allow us to remove the money from that trust, put it into the survivor's trust only when it makes sense from an estate tax planning perspective. Yeah. But then we capture a stepped up basis on everything. There is a way to do that.
Absolutely. So to wrap this up, if you're thinking about selling real estate or appreciated stock, talk to us. If you haven't looked at your trust structure in a while, talk to us. Easy to find us, obviously, Gilfix.com. And again, understanding capital gains taxes can have a massive impact on your family's financial health. Now, property taxes and Prop 19 in California. What do you need to know? If you follow us, we talk about this all the time. Prop 19 is a new law. It's now part of the California state constitution. And Mike, lead us briefly through what this is and what it means.
Sure. So as an overview, most of us fondly remember and kind of love the legacy of Proposition 13. Jarvis and Gann, the two guys who kind of made this happen many, many years ago, kind of in the 70s. The idea was to roll back property taxes, very small annual increases in property taxes. Then we had Prop 58, which allowed mom and dad to pass along the residence to the kids without any property tax increase, regardless of whether they lived in it or not, and another $1 million in assessed value. That was Prop 58. So all of that is gone. All of that is gone, wiped out by Prop 19. So now we have dramatic property tax increases when mom or dad pass away and pass along the property to the kids. So we have first the primary residence. Much information is out there on the net saying that if your kid lives in your residence, makes it his residence, no property tax increase. Absolutely wrong. Absolutely wrong. If your child makes your residence his or her residence, there will be $1 million worth of forgiveness. So in a simple example, if the value of a home is $3 million and your child moves in, the new assessed value is going to be based on $2 million. $1 million is forgiven, but still there could be a $20,000 property tax increase. It's absolutely massive. If it's a rental, if it's the cabin in the mountains, the vacation home, there's no protection whatsoever. So we're looking at these dramatic property tax increases that in so many cases is going to compel the kid who inherits the house to sell the property. And today there's a new local newspaper, the Los Altos Town Crier, and they actually have an article about this problem where a man inherited property.
Yeah, let me so let me hold this up. This is the Los Altos Town Crier, and you can Google the Los Altos Town Crier, and Mike is quoted in this, but this is an article about Prop 19 and a Los Altos homeowner who inherited a home from his parents and was caught flat-footed and had no idea what was going to happen. So it's happening to everyone. And I think the key point is we have solutions for it. We're going to talk about that in a second. There are ways to avoid this.
That is the key.
Else you want to add, Mike?
Well, that is the key. that there's no awareness. Our feeling is that for every one person who knows about this, there's 100, there's 200 who never heard of it. They might have heard of Prop 19, but they heard of some of the apple pie elements of Prop 19. Totally unaware of this reassessment issue, which again, in so many cases, is going to compel the next generation to sell the house when mom and dad deeply wanted them to retain the family home, the residence. So important.
And I think a key point we like to make too is the family home is not just a structure, right? It's your home. And as Mike said, there's a lot of misconceptions that, oh, well, as long as I live in my parents' home, I'm protected. As if you live in the Bay Area or West LA or San Diego or many areas of California, that's just not true. If the house is worth more than $1 million, more than the assessed value, Prop 13 protected value, there will be potentially a massive tax increase. So anything you want to add, Mike, just about
well, no, I'm excited to see the next section because, when you lay out the real numbers, I mean, it brings it to life. We can say these words. There'll be a big property tax increase. That's ambiguous. You can't get your head around it. But hey, everybody, just get the numbers. These very real numbers that Mark's going to share with you here in a couple of minutes.
Yeah, and I just want to share a recent story of a client who came in. So I think that article actually probably is a very similar story. But very recently, we had a call from a woman named, let's call her Sarah. She had a meeting with me because she understood we do a lot of talks about Prop 19, and she knows that we have solutions for it. And we'll go into what our solutions are or how we can help, what they can achieve in a second. But she called us because she had inherited a house in Mountain View from her father. She was the only child, and her father literally built the house with his bare hands back in the 70s, the late 70s. And there'd been some other upgrades, but the house is worth over $3 million. And he'd owned the house the last 40 years. And so the assessed value, the Prop 13 protected assessed value was extraordinarily low. Let's call it $300,000. But the house was worth $3.3 million. So it was worth over $3 million more than the assessed value. His daughter, Sarah, did not make a lot of money. I think she was a nurse. Wonderful profession, but you don't necessarily get paid that well in Bay Area housing terms. It's crazy. And she just wanted to keep the house for her family. That's it. She didn't want to cash out. She didn't want to have to leave the Bay Area. She's like, hey, I can stay in Mountain View and live in my dad's house where I grew up. Dad passes away. He leaves it to her, and she got a tax bill in the mail a few months later. And it said that her taxes were going up $24,000 per year. And she was like, wait, what? So she contacted us to say, hey, is this right? And if it is, what can we do about this? And it was right. And I'll show you some numbers in a second. And unfortunately, it was too late to really do anything about it. Because if you wait till someone is gone or wait until you've already transferred a house, it's too late. You only get one chance to keep low property taxes. So we're going to talk about that a little bit more, but it's striking. And I think she ended up having to sell the house. We couldn't really do much for her in this case. Had we met with her dad before, we could have protected it. We could have kept those taxes low. So let's just give some illustrations here about what is at stake. So I'm going to give just a couple examples. So let's talk about a house that is worth, again, what I just said, a $3.3 million home with a $300,000 assessed value. And let's say that someone lives in it. Well, I'm an Excel nerd. I used to be a management consultant. I like creating Excel spreadsheets. So this is an assumption, a $3.3 million home, which in parts of California isn't even that big a house, which boggles my mind. It always boggles my mind, but it is what it is. So let's say the house is worth $3.3 million, $300,000 assessed value. If you can plan ahead and lock in those low property taxes stay at about $3,300 a year in perpetuity after it's inherited or whenever it's transferred. If you don't do the planning, even if a child's living there, $2 million is exposed to a reassessment because again, it's $300,000 plus $1 million is protected if a child's living there. $1.3 million is protected. The house is worth $3.3 million. That's $2 million unprotected. Taxes go up by about $22,000 a year. Now, over time, I'd circle these boxes. Over 10 years, that's $240,000. Over 30 years, that's almost $900,000 in unnecessary extra property taxes. And we need to shift how we think about taxes and savings. Money that you have to pay in extra property taxes is actually even worse than it looks because you have to earn more in pre-tax money to have after-tax money to pay these. Because remember, you can only deduct up to $10,000 in state and local taxes from your income. So the bottom line is to pay this extra $900,000 in taxes, the child would have to earn an extra $1.3 million over 30 years to pay this, because they have to earn it. It gets hit by income taxes, and they have to pay the property taxes. You can deduct some of those, but it's very limited in
It's
California.
astounding. It's just astounding.
Yep. And let's say a child doesn't live in the house, so they don't even get the $1 million in protection. For the same situation, the numbers get even worse. Over 10 years, it's $360,000 in extra property taxes. Over 30 years, it's almost $1.34 million in extra property taxes that have to be paid. So it's so crucial to protect this. So this is for a residence. Now let's just talk about a rental. So let's say you have a rental property, and maybe you have a child with special needs, or maybe you want to leave this. We have some clients who are lucky enough to have a home and a rental, and they want to leave the home to one child and the rental for the other child, just to kind of be fair. As we talked about, zero protections from reassessment for rental properties, again, unless you plan ahead. So there isn't even the $1 million in assessed value. Whatever the rental is worth at the time of your passing, if it goes to your kids, and if you don't plan, that's going to be used for a new reassessment. So, I don't mean to hit this too hard, but the numbers are staggering over time. For a rental property, let's say that a rental property is worth $2 million. And the assessed value is only $200,000 because the family's been fortunate to have it for a long time. If they plan ahead and they lock in the low property taxes, well, taxes stay at about $2,200 a year. They go up about 2% a year. They don't plan, property taxes go up to about $22,000 a year, and then they go up from there. So again, over 10 years, that's $216,000. Over 30 years, it's $800,000 in extra property taxes. And again, that's money. You have to earn more to pay these taxes. So, and in many cases, that makes a rental uneconomical. A lot of rentals in this area, the cash flow is okay, but not great. So then maybe they do a 1031 exchange to get out of it. But hey, we don't want your family to be stuck in that situation. So we want you just to imagine what's possible when we plan ahead to save your real estate, because we can. Let me just talk briefly about what we've developed. So if you don't plan ahead, again, your kids are facing hundreds of thousands of dollars in extra property taxes. But we have developed solutions, and we call it the Gilfix and Leopold Dynasty LLC process. Contact us. We got it. It's very case by case. It's different for every family because we have to think about capital gains tax issues. We have to think about property tax issues. We have to think about estate tax issues. But the approach can work to lock in low property taxes for your family. And we use entities and special trusts, or a combination of the two. There is no one size fits all approach because there's no one size fits all tax problem. But we've already worked with, I'm not exaggerating, a couple hundred California families on this, and we're getting more clients coming in every day. So if you have any questions about this, contact us, because we can even layer in asset protection for the next generation. We can keep property taxes low, get the stepped up basis, and protect the property for future generations, sometimes with some protection against lawsuits or divorce, depending on how we structure it. So it's incredibly powerful what we can do. Talk to us if you have these questions, gilfix.com, very easy to find us, of course. Any notes you'd add, Mike, before we go to our final tax topic?
No, I think everybody has it. If you own real property and you want it to stay in the family, we got to deal with it. I mean, there's your bottom line. Don't wait. Don't think you'll get more information. You can, but if you hesitate, or the head stays in if your head stays in the sand, you lose.
Yeah, and we don't want people to be left behind. As we said, we've helped. It's in the multiple hundreds of families now, and we're very worried that many families are going to be caught completely flat-footed, just like Sarah, who I talked about before. So take action. Talk to us if you're not sure, and we can come up with solutions. We have solutions that work. So let's now go to the final subject of today, and then we'll go to some action items. But that is estate taxes. So let me share this slide going back and forth. Always an adventure with Zoom. So estate and gift taxes and the coming cliff. What do you need to know? Who needs to be worried about this? And if you are worried about it, what do you need to do? So Mike, why don't you lead us through estate tax laws as they are, and most importantly, where they're going?
So hold on to your hat. If you're thinking immediately, by the way, that you don't have any estate tax exposure, it's not your issue, you're not rich enough, hold on. I doubt that's true. I think the vast majority do have this issue here in California. Okay, what's the current law? This year, very high level of protection. An individual can pass along $12.92 million to the next generation without exposure to the punishing 40% estate tax. If you're a married couple, it's double that amount. So only individuals with extremely large estates are exposed to the estate tax this year. Another key element now is the annual exclusion, which is a point we always want to emphasize. It's the simplest way of transferring money out of your estate. Most of us think in terms of the $10,000 annual exclusion. It's gone up. It's been kind of cost of living adjusted. This year, it's $17,000. That's the amount of money you can give to anybody at any time. So sounds very high, this level of protection. Sounds like you don't have to worry about it. Well, here comes the cliff. Here comes the cliff. Okay, so what do we mean by that? Not that far away. Not that far away. In 2026, January 1, 2026, the current levels of protection expire. The legislation that extended that protection sunsets. It had a sunset provision. It ends at the end of 2025. So at that point in time, the level of protection goes from about 13 million down to about 6.5 million per person. Now that's still a lot of money, no question about it. That's still about $13 million for a couple. No question, that's a lot of money. But if you own homes around here, with the mortgage rates being higher, in this community, the property values have maybe leveled off. They have not plummeted. They're going to go up again. I think most of us believe that. So in other words, if your estate is currently, if you're a single person, if your estate's around 5 million now, it's going to grow. Property values grow. Your investments, we are optimists. We believe they're going to grow. So at some point in time, you're likely to have an estate that's going to be exposed to the estate tax. And that assumes it stays at 6.5 million. It could drop lower. I mean, many of the presidential candidates last time around, they said the level of protection should be down to 3 million or 3.5. But again, we're going to have gridlock in Congress unless we have a surprise in 2024 where one party controls everything, maybe then, but we don't think that's going to change. So we're looking at this dramatic change in the level of estate tax protection. If you're a couple and your estate is worth maybe 9 or 10 million, again, think about growth. There's going to be exposure. So if there are some pretty straightforward, manageable steps you can take right now to lock in protection, to just be kind of circumspect, plan for the future, make sure you're not going to be exposed to this tax.
Yeah, and I just want to add one thing that,
Sure.
Mike, that you talk 5 million, 6 million is a big number, but if you just own a house in California, in many parts, that might get close to that. And keep in mind, life insurance benefits. So if you have a life insurance policy, that's all part of your taxable estate, retirement accounts, savings, investments. So your estate is almost certainly larger than you think.
Right.
And this is a good problem to have.
Yeah, and let me add, I mean, if you own property, as many of our clients do, if you own property in another country, that counts. That counts. So the estate groweth as you consistently, when we ask somebody what the size of their estate is, if they just kind of think it over, they'll come up with a number. Consistently, they're about 20% too low. Yeah. So whatever you're thinking your estate is, it's larger. It's larger.
That's right. It's a good thing usually. And in this case, maybe not so much. So let's talk about what you can do to reduce estate tax exposure if you're worried about this. We want to plan for success, right? So maybe you're not there yet, but we hope that by 2026, you're going to be there, or maybe later. Your estate's hopefully going to keep growing. So if you have a larger estate, if you're already close to these limits, you definitely need to plan, and we need to meet with you, because last time there was an estate tax law change, I think we had to turn people away as it got close to the deadline because we were overwhelmed. So we actually have clients who have already set meetings in mid-2025 with us to talk about estate taxes. So if you have a larger estate, there are a lot of techniques we can use. So here's just kind of a list. So by the way, we have a Gilfix Law webinar. It's called Next Level Estate Planning for High Net Worth Families. If this is an issue for you, we have a specific webinar that's on our YouTube channel for that. We're going to give more educational content about this, but I want to talk about just some techniques that we can use. So as we get close to 2026, one simple technique is, well, you max out your exemption, you give it all away. While you're still around, use up that 12.92 million. And then when it drops, okay, well, you don't have any left, but you already used 12.92 million. And it is use it or lose it, by the way. If you don't use all of it, if you give away 6 million right before it drops to 6 million, you think, oh, I have 6 million left, so I should be good. No. They will count whatever you've already given away against whatever the new limit is. So you need it's use it or lose it. But there are a lot of other sophisticated techniques we can use to avoid estate taxes, or at least dramatically reduce it. I mean, this is an area of planning where, you spend $30, $40, $50, $60,000 on tax planning, you can save hundreds of thousands or even millions. So this gets very complicated. There's a lot of tools we can use. So Mike already talked about charitable remainder trust. There are spousal lifetime access trusts where one spouse uses his or her exemption, locks it in by creating a trust for their spouse. There's the concept of discounting, which is something when I came into this field, I was like, what? So discounting at a high level, I think this is an important concept. We'll talk about this more in other webinars and videos. But let's say you have a house with $1 million. If you give away 50% of it, well, that seems like that's $500,000 worth, right? The IRS understands, though, that you can't really sell half of a house, right? That's very complicated. It's tricky. So you get to discount the value of that gift. So if you give away half of a house worth $1 million, you can often get discounts of 20 or 30%, sometimes even more on the value of that gift. So you can give away what really, in essence, can be on paper $500,000 in value, but you only have to use up $350,000 of your estate tax exemption. You made $150,000 basically vanish for estate tax purposes. It's not that simple. That's illustrative. Don't quote me on those exact numbers. And of course, this is not legal advice. This is illustrative educational. We need to talk to you about it in more detail to really understand it for you. But there's so many other tools we can use, combine this with LLCs and control and partnerships. There's so many techniques we can use. The bottom line is, again, if you have an estate, if you're single and you have an estate in the $4 to $5 million range right now, including your house, we need to talk about this. And if you're a couple in the $8 to $10 million range, we need to start thinking about this. We need to think about the structure of your trust and all these techniques we can use. Now, there is one, Mike mentioned the $17,000 annual exemption. That's the amount you can give away to anybody without even reporting it to the IRS. Mike, why don't we talk about a fun tool that you can use for grandkids? And I'm going to bring up the picture in a second. Crummey Trust. Why don't you lead us through that?
We never want to let a tax or trust webinar or seminar go by without talking about the Crummey Trust. And for those of you who are wondering, I'm the one on the right in the picture that you see. That's my wife, Myra, on the left, also an attorney here, and our grandson, Miles, in the middle. Hello, Miles. So what is the Crummey Trust? Why do I like it so much? Most grandparents are interested in doing something supportive for the grandkids. The grandkids are perfect. The kids, all screwed up, all kinds of things wrong with them. But the grandkids, absolutely perfect. So this is a way to express that love and devotion that you have for your grandchild. The idea here is you set up this trust and you're going to be shifting money into it every year without details. You can't use this $17,000 annual exclusion, giving it away, if it's going to go to an irrevocable trust. So if you just set up a regular trust, irrevocable trust to take care of a grandkid, you can't use that annual exclusion. This trust, it lets us use a technique to cleanse the gift to make sure that we can use for a couple the $34,000 annual exclusion to put money into a trust for a grandkid. Now, I generally prefer this to 529 plans because even though there's tax preferences for 529 plans, which we support, which we think are great, but with the Crummey Trust, you have much more flexibility. Rather than using the money only for education, and you can use the money for education for the kid, you can use it for healthcare. You can use it for housing, much more flexible. Also, as a practical matter, a 529 plan kind of ages out when the kid is done with education. You can set up this trust so that it doesn't terminate until the child is 35 or 40, any age that you pick. Somebody would be the trustee of that trust. Presumptively, it would be one of that kid's parents, your kid. So you're not going to control it. The money's going to be removed from your estate. You're locking in this support for the benefit of that great grandchild. It's a wonderful, wonderful planning tool. Not the only one, but it's one of my favorites. That's why I call it the grandparent's delight.
Yes, and Crummey is not because they're crummy. It's the name of the court case that created these. It was, as you saw, it's not spelled crummy like a crumb from a cookie. Lots of fun legal terms we all deal with every day. And sometimes you guys got to remind us we're using terms that you don't know because we lawyers geek out over this stuff. We forget that we're not normal. Let me just wrap this up just to say, estate and gift taxes, it's so important to understand it. You don't need to have a huge estate. Well, relatively speaking, you don't have to have a massive estate to be worried about this. Laws change all the time, but we already see this coming cliff in 2026. So if you already have a larger estate, talk to us. Mike also wrote a book called Beat Estate Tax Forever. If you are a current client, talk to us. We can give it to you on a discounted basis for meeting with us. We'll usually give you a copy. If you're not a client, you can order it on Amazon or through our office. But most importantly, if you're worried about this, talk to us. And again, you might not be close to the limits now, the 12.92 million. But in 2026, you very well could be. And we just have to keep our eye on it because these laws change over time. So again, we have saved, we're not going to give any guarantees, but we've saved hundreds of millions of dollars over the years. I'm almost certain, maybe even in the billions, for all the clients we've helped with estate tax planning, using techniques that are all tested. We don't cut corners, but there are so many ways that you can totally legally and totally using accepted techniques dramatically reduce this exposure. And it's win-win. You can help out your family while you're around as well to use a Crummey trust. So contact us, gilfix.com, if you want to discuss this, or if you know somebody, if your parents, your grandparents might face issues, share this with them and subscribe to our Gilfix Law channel to learn more about that and to find that other video as well. So we hope this is really helpful. We're going to move on. So estate taxes, gift taxes, we need to understand that. So we went through a lot here. I mean, this is a lot. So we're going to get to some questions in a second. And I want to just include this with the action items you should take, the action steps that you should take, because we want to make sure that you are in that category of the families that understand these rules, because for better or worse, over time, the families that understand these rules, that understand gift tax, understand estate tax, understand property and capital gains taxes, they move ahead of the families that don't. And we don't want you to be left behind. We want you to be one of the families that takes action, that understands this, that sets up their estate plan the right way. There's so many other pieces to an estate plan beyond just dealing with these tax issues, of course, special needs issues, asset protection issues, making sure you're covered. But we want to get the chance. We want you to be empowered. So what we went through here today gives you a start. But if you are ready to take action, of course, we would love to get the chance to meet with you. And I want to have some questions. Should we meet with you? Should you meet with us? Some questions to ask yourself. Well, do you have an estate plan? If you don't have an estate plan in place, or if you don't have a living trust, power of attorney, you need that. We absolutely can help you with that. We've helped thousands of families, thousands of clients over the years just to set up that plan. But if you have a plan, it's been a while, we need to take a fresh look, whether we worked with you in the past or not. Do you have the right trust structure? Are you addressing these issues? Have you thought about capital gains tax issues? Do you own a home or a rental property in California? Do you want to leave it for future generations? Let's at least explore Prop 19 issues and what we can do to protect it. Maybe you decide not to take action, but most of the clients we talk to about this end up taking action, and we have solutions for that. And are you just generally concerned about property or capital gains or estate taxes and how it impacts your estate plan and your strategic decisions in the next few years? Talk to us. And do you want to protect assets for future generations? Or do you have a child with special needs? These issues are especially acute there. Talk to us. We'd love to get the chance to meet with you. And just imagine, whether we get the chance to work with you or not, just imagine what's possible when we plan together. You need that team. We're building some integrated legal and financial services, by the way. If you're looking for help in an integrated way where you get one hand talking to the other, financial planning and legal planning, we're building that. But most importantly, you need to communicate because there are a few high leverage moments in life where if you make the wrong decision, it can end up costing your family so much. You can make the right decision. It could be the difference of hundreds of thousands or over multiple generations, many millions of dollars, even if you don't have that much right now. You look at compound growth and all that. So make the right decisions. When you have these big decisions, when you're structuring your estate plan, make sure you have an integrated team. And we would, of course, love to be a part of that. And again, we'd love to also, we always talk to financial advisors if people want to bring them in, and we're building, again, that team of financial integrated legal and financial services. But most importantly, if you do want to talk with us, contact us at gilfix.com, 650-493-8070. For existing clients who are members of our Peace of Mind program, you can meet with us every year. But if you're not a client or if you're not a member of our Peace of Mind program, just contact us. And we're happy to go through how we can help you. So bottom line, take action. You are empowered right now with knowledge, with an understanding, at least for now. I know your head might be spinning, but you're empowered with this understanding right now. And it's going to fade the moment you walk away from this, whether you're watching as a recording on YouTube or whether you're watching this live. The moment you step away, you get inundated with other stuff that you have to deal with. So I would just say, contact us. If you want us to reach out to you, you can enter your name and information in the Q&A function if you're watching this live, or in YouTube, you can reach out via direct message. But most simply, gilfix.com, or call us at 650-493-8070. And again, if you're watching this now on Zoom, enter your name and your information in the Q&A function. We'll reach out to you. We're going to get to some questions in a minute. But again, I just hope that you got a lot out of this. As I like to say, an educated decision is a good one. You guys are empowered now. And if there's anybody in your life or your circle who could benefit from this, share this. let them know. We at Gilfix and LaPole would love to get the chance to help them, but even if we don't, we want you guys to understand these rules because we get tired of only the ultra high net worth people with huge teams. They seem to find ways to avoid taxes, and us regular folks can't. It's just not true. So we want to be part of that team. So hope you got a lot out of that. Now we're going to get to some questions, but thank you guys so much. So Mike, why don't we go to some questions? We have some really good ones I already see. So
Sure.
why don't you, which one do you
I'll
want to
get
start with?
started. I'll get started. So one from Prima says, what if you're a beneficiary child of a trust and you've lived in the primary residence for 4 years? Does the stepped up basis apply, or does it have to be transferred before selling to get the stepped up basis? Okay, the stepped up basis, remember, happens if the owner of the property, maybe that's your parent, when the owner owns the property and passes away, that's when the stepped up basis happens. So if a parent is already deceased, the basis is not going to go up again. I'm not sure why you mentioned being the beneficiary and living there, because again, if it's in your parents' estate, whether you're there or not, there's a stepped up basis.
Yeah, and we see a mistake where parents give a property away while they're living, thinking they're helping the kid out. Lose the stepped up basis if you do that, or even if you give away pieces of it. So,
Yeah.
good question though, Prima. We have a question from Arthur. Is there a choice of the date for the stepped up basis when an owner passes away? No, there is no choice. It's the day that they passed away. So the day that you pass away, for someone in your family, I know it's kind of morbid, but we have to talk about this. The date that someone passes away, whatever the fair market value of real estate or stock, whatever it is on that day, that's the new cost basis. If you sell it soon after, well, you might have zero capital gains tax exposure. Yeah, a good question about you said AB, sort of anonymous attendee. You said AB trusts are not needed unless there's a large estate. How large? So that question of, do I need an AB trust or not? Now, there are other considerations aside from tax. So AB trust can be used just to, if you have a second marriage or kids from different marriages, there are good reasons to have it no matter what size estate you have. But Mike, what guidelines would you generally say would we want to start thinking, you know what, you should have an AB trust?
Right. We talked about the arguable downside of losing a stepped up basis on half of the estate at the second death. I hope you followed that. Well, on the flip side, a benefit of not having the assets in that B trust, of not having that asset in the estate of the survivor, is that if the estate is too large, that will, if the estate of the survivor is too large, all that money is excluded from the estate if it's in that B trust. No stepped up basis, but assets in that B trust might have grown dramatically. And if it's in the B trust, it's not going to be part of the taxable estate. See, that makes the point that every case is different. It's not just the size of the estate, it's the nature of the assets. It's how optimistic or pessimistic you are about the growth and value of identified assets. That's sort of the art and science of which assets go into the A or the B trust, if you have it, and then in turn, should you retain that structure or not? So no one answer. If it's 10 million plus, we think about retaining the AB trust as a general matter.
Yeah, so I think that $9 to $10 million is where, for tax purposes, the AB trust still probably makes sense alone. And we have some contact information. We will reach out to you if you just gave us your contact information. And if you're watching on YouTube, feel free to leave a comment, a question. We're trying to get to those. Comment, questions, subscribe to the Gilfix Law YouTube channel. We do weekly webinars, and we do a lot of other videos now where we have a machine kind of up and running. We're very excited about it. It's growing really quickly. So check out the Gilfix Law YouTube channel. So I think that's it for now. We're almost at the hour, so I think we're going to wrap it up from now. But thank you guys so much. We got a lot of really good questions. Sorry we couldn't get to all of them. We will reach out to the folks who gave us your contact information. For those of you who didn't, who want to meet with us, Gilfix.com, pretty easy to find us, GILFIX.com. We'd love to get the chance to meet with you. If we worked with you in the past and it's been a while, hey, let's set a review meeting and we can help you with all of this and to sort through what issues you need to be aware of. So again, thank you. Spread the word. Please share this talk with others. Let other people know about the webinars we're giving. We want to empower you with knowledge. We want to educate and empower. And we get to work with a few of you. Great. And that's a privilege. And we just want to spread the word. So on that note, as my mom likes to say, I hope everybody's staying safe, sane, and healthy. Stay tuned for more. Give us a call. But I hope you got a lot out of this, and we'll